time I attend one of the meetings, I hear this is a topic that they would like to host for one of their upcoming meetings. So in the spirit of collaboration, we decided to co-host, and I have the opportunity to introduce our sponsors of today's workshop. Tim Zunker with the Shakopee Area Chamber of Commerce, Mark Jacobs with the Dakota Scott Workforce Development Board, and Michael Wernicke, Business Development Manager with the Scott County CDA and Center for Entrepreneurship. So I will turn it over to each of the sponsors, a word from our sponsors, before they introduce our speakers. So welcome, thank you.
I think we're still morning, right? Good morning, everyone. Like Joe said, Tim Zunker, the president of the Shakopee Chamber of Commerce. I would just say that thank you for all being here today. One thing is with the changes that have happened the last couple of years in the legislature with employer mandate changes and different things like that, I think it's very important to talk to the experts on what options are available from an implementation, but the private option standpoints with certain things coming up, paid family medical leave, and then currently what to do with their save time for the small business community, and also that it's a fluid situation at the legislature right now with specifically paid family medical leave. So we'll continue to update from the Chamber of Commerce side. There's bills in the legislature in the Senate. Senator Seeberger is an author on one of them that's going to make some changes and tweaks within the paid family medical leave law. In the House of Representatives, Representative Baker, who chairs the Workforce Committee, has had multiple bills that would make changes to there. And right now they're in the process of negotiation in each body for their omnibus bills. So we're going to see what gets included, what doesn't get included, and then what passes off the House floor, what passes off the Senate floor. So I think this is a good starting point with current law and how it's passed, but then also we can update as changes are made. I'm going to hand it over to Mark Jacobs.
Thanks, Tim. Director for the Workforce Development Board for Dakota Scott County, and Joe's on board too. He's actively involved. And as Joe mentioned, this topic is a big deal. We're hearing it from our employers who participate on the board. So pleased to be a sponsor for the event. Thanks for the opportunity. And a deeper dive on the Paid Family Medical Leave Act is going to happen in Eagan next week, 8:30 to 10. At loss for D is the content provider for that. But the chambers are helping host it along with the Workforce Development Board. If you want more info, talk to me or Joe or Tim, and we'll connect you to that opportunity.
Perfect.
Thank you for coming today. My name is Michael Wernicke. I'm the Business Development Manager for the Scott County CDA. I manage the Center for Entrepreneurship. This is one of our monthly educational series that's available for businesses. And on behalf of the Scott County CDA, we want to thank the Shakopee Chamber and Dakota Scott Workforce Board for being here and bringing our speakers. So I'd like to begin by introducing our speakers. We have Kevin Mosher, who is a partner and labor and employment chair at Thompson Co. Cousins and Irons LLP, serving as the partner in charge of the firm's St. Paul office. With extensive experience in general litigation, he represents businesses and insurance companies nationwide, focusing on employment and general liability claims. As a Minnesota State Bar Association board certified labor and employment law specialist, Kevin provides strategic counsel on HR compliance and workplace issues. He is also the founder of My HR Genius, offering legal solutions tailored for HR professionals. And our other speaker today is Gina Lemon, who is an accomplished human resource leader. She began her career with Fortune 500 companies, including UPS, Target, and Ameriprise Financial, and spent the majority of her career at Timberland Partners, where she helped grow the organization from 150 to over 500 employees across 18 states. Recognized as a notable leader in HR by Twin Cities Business Journal, in 2020, Gina brings a passion for transforming businesses through people and processes. Her extensive certifications reflect her commitment to continuous learning, now leading HR consulting services at Flagship. Gina helps clients build capacity, strengthens teams, and drive meaningful results. So if you would with me, let's welcome our presenters.
Thank you.
this close enough? Can you hear me, people online? Okay, great. I'm Kevin. Thanks so much for coming today, and hopefully this will be pretty informative. We are going to talk about, well, we have planned to talk about 4 different topics, but we're going to start with 2, and we'll see Earn Sick and Safe Time and PMFL, and we'll see if we have any time for the others. I suspect most of you are probably most interested in Earn Sick and Safe Time and PMFL, but we did also plan to, hang on, just want to make sure I'm, just click there. Okay. Okay, great. But we did also come prepared to talk about misclassification issues as well as drug testing, cannabis issues in the workplace. All very hot topics the last couple of years for employers. In the state of Minnesota. So, and I'm going to apologize to people online. I do walk around and move around a little bit while I speak. So sorry if Joe, if you're watching online, just be like, you're way out of the screen. And so apologies in advance. If you have questions, please interrupt. Raise your hand. Let's talk about it. There certainly we have time here to take questions, and I want to make sure that we're answering between me and Gina, that we're answering the questions that you came today and that you have through the presentation. So definitely feel free to ask. Okay. Any questions about that before we jump into ESST? Earn Sick and Safe Time? Okay. Everybody in here kind of familiar with Earn Sick and Safe Time? We have a general concept. Hopefully we're all implementing Earn Sick and Safe Time. It went into effect last January 1, 2024. So what is, and I don't want to assume too much. Some of you probably have like really great deep knowledge on ESST, and some of you, it might be more cursory knowledge. So apologies if some of this is just a little too basic for you. But Earn Sick and Safe Time became the law of the land in Minnesota for Minnesota employees. If you have employees in other states, it does not cover those other employees. If you have employees working remotely in other states, it does not cover those employees working remotely or other facilities that you might have. But if they are working in the state geographic boundaries of Minnesota, as of January 1, 2024, you have been required to provide Earn Sick and Safe Time, which is a type of paid leave. It also requires that you amend all of your paid time off policies, whether you have a generalized PTO policy or a vacation policy plus this Earn Sick and Safe Time. But every employer in the state of Minnesota needed to revise their policies as of January 1, 2024. I've heard from a lot of companies, they're like, no, we give PTO, we give vacation, we're good. That's not true. There is no way that you could have been compliant with the state of Minnesota law on this because the law itself requires a lot of policy revisions and things that need to be stated around retaliation and what it all covers and all that. So if you haven't updated to be compliant with Earn Sick and Safe Time since the law went into effect last January, add that to the many things that you probably have on a to-do list.
Can I ask a quick question? And again, no judgment, because we're all trying to get better as employers. I'm just curious, how many of you have updated your employee handbook within the last year? If you want to raise your hands. Okay, great. Just curious, thanks.
Yeah, how many of you are like constantly updating your employee handbook because it's like a never-ending project that you always think like, oh, I got it done for this year, and then it's like, oh my gosh, they just changed things at the state legislature, and so. So what is the Earn Sick and getting into the details of Earn Sick and Safe Time? What does it do? It requires that you provide all of your employees working in the state of Minnesota day one that they start working and start spending hours working for you. It requires that you provide them with paid time off. Now, you can do that by one of 2 methods. You can do that by front loading the paid time off for specific reasons, and we'll talk about those specific reasons, or you could do an accrual method. Out of curiosity, how many of you are using the accrual method for at least some of your employees? Yeah, about half, and then the rest front load. And then some are like, I don't know what ESST. I'm just kidding. Nobody knows that. So front load, and you can bifurcate, right? So I write a lot of policies where I'm front loading for managers and then accrual method for hourly employees, for non-exempt hourly employees. Totally fine. You do not need to have, you do not need to pick one or the other. You could do accrual or front load method. But in any event, you have to choose, have to have a policy on this. And then we'll talk about some of the details as well. But before I move off this slide, the other thing that you had to do was documentation requirements as part of the law that you need to, on your pay stubs, work with your payroll providers and to ensure that it's reflecting the balance used during that pay period as well as the accrued earned balance that the employees have. I've gone through a number of audits in the last year, or some more like anyway, gone through a number of audits, and the government, the state government, and then also the city of Minneapolis is also, on this issue, and they're ensuring that employers are having their payroll companies update the pay stubs. So definitely a thing to do. I know that was pretty difficult heading into 2024 to ensure that the payroll companies were fully updated. Okay, so who's impacted? A little bit of this is redundant. Who's impacted? Everybody. Everybody in the state of Minnesota is impacted by this. Now, employees, the rule is that the employee needs to work 80 hours in the state of Minnesota. So is there a world where you might hire somebody from like Wisconsin who's not worked in the state of Minnesota and they're technically not eligible for ESST? Yes. Yeah. But for the most part, the employee just has to work 80 hours in the state of Minnesota. And so if you're hiring somebody that's coming from another company in Minnesota, they're going to be eligible day one. A lot of companies misunderstand this as an 80-hour threshold before they're eligible. That is not true. It is an 80 hours of work in Minnesota. And you might say, that is the dumbest rule. Like, why do we care about that? And the answer is, pretend that you have a consulting business and you have employees in like Chicago and they come up to consult in the state of Minnesota and they are maybe here a week, or they're here on a project of some sort and they're here for a week. And it's like, you don't need to have those employees be eligible for earning Minnesota paid sick leave, right? We have 5 offices in Texas. And so if I bring an associate up to Minnesota from Texas where they don't have paid anything, you can imagine. And so if an associate comes up to my office to work for like a week or 10 days, I don't suddenly have to start having them earn paid time off or under ESST, because they're not, even though they're technically working in the state of Minnesota. So that's why there's an 80-hour threshold. If you have employees in other states, you'll see that other states that have paid leave laws like the ESST, and this law is modeled after laws that are in a number of other states. So you'll see that they similarly have 80-hour thresholds. So that's why the 80 hours. Benefit year. In your policy, you need to be defining what the benefit year is for the ESST. Under the ESST, under the accrual method, you can either earn 1 hour for every 30 hours of work minimum. You could give a better ratio. You could pay more than that if you want. But it's got to be a minimum of 1 hour of earned ESST for every 30 hours of work. Or you could front load as well. And we'll talk about those in a second. But you have to define what the benefit year is. And the reason the benefit year is important is because if you're on the accrual method, you have to allow for carryover from one benefit year to the next benefit year. You can choose the calendar year, January 1 to December 31st. You could choose May 1st to April 30th. April 30th? Yeah. April 30th. You could choose the person's anniversary date. So you could have, so every individual has a different benefit year. Whatever you want to do, you can choose it, but your policy needs to define what that benefit year is. And that's important because of, again, because of the accrual method with rolling over. The other thing, and this changed in the last legislative session after the law went into effect. Initially when the law came out, it was horribly written, and they wrote it such that if the employee, you had to give the employee the lowest increment of time off that you measure under your timekeeping system, right? Now, for some employers, that's like 15-minute clocks. For some, it's like 6 minutes. A lot of you probably are using 1-minute clocks, like perfect time on time and attendance. Is that some of you are? Yes? Like using 1-minute increments on time. So that literally means that you would allow somebody under that system, you would allow somebody to take off like 1 or 2 minutes of earned sick and safe time. Absolutely silly and ridiculous. Didn't align with what Minneapolis and Duluth and Bloomington and St. Paul were doing with their earned sick and safe time policies, rules. And so they changed it in the last legislative session to say that you could have a minimum of 15-minute use increments. So your policies hopefully will reflect that.
Kevin, another thing, did they change that you need to be able to use it for bereavement as well?
Yes.
Okay.
Yeah, earn sick and safe time for bereavement. Yeah, and for planning for funerals as well. So prep for funerals. Okay, so front loading. This is one of the 2 methods that we have. And it sounds like some of you are using front loading. But with front loading, you have 2 options. So with front loading, you could either go with an 80-hour front load option, which means the employee at that time, like at the beginning of that benefit year, gets, boom, 80 hours or more, but at least 80 hours of earned sick and safe time. And if you do that, it's a use it or lose it policy. You don't have to allow carryover, rollover into the next benefit year. You can just say, use this 80 hours or you're done, right? And sometimes employees will use it, sometimes they won't, but you don't have to pay it out. You don't have to let them roll it over. It's a use it or lose it policy. That's only if you allow for 80 hours or more. And I get the question a lot, like, oh, can I prorate that? No, we can't prorate that. If you prorate it, put the person on the accrual method. But there's no prorating under this law. It's either 80 hours or more than 80 hours. The other option that you have is to go with 48 hours, or between 48 and 80, but at least 48 hours. But if you do that on the front load, then you have to pay out any unused portion at the end of the benefit year, right? So if your benefit year is, just to say, the calendar year, January 1 to December 31st, and somebody doesn't use 8 hours of their 48, you have to pay out those 8 hours at their rate of pay at that time. And so it can be kind of a little bit of a bonus to them. But if you had them on the 80 hours and they have 8 hours left, they lost it. The 8 hours is gone. You don't have to pay it out. Can you if you want to? Sure. But you don't have to under the law. Does that make sense? People are familiar with that? Great. Oops. Did I just go backward? Okay, so I'd already mentioned the accrual method. And the accrual method is that the ratio has to be at least 1 hour for every 30 hours of work. You can set it lower if you want to do it for 1 hour for every 25 hours because the person's got years of employment with you. That's fine, no problem. But it can't be more than that. So it has to be at least 1 hour for every 30 hours of work. And what is work? Work is actual physical work. It is not time off because of Easter or holidays or any sort of other paid day off. It is actual physical work punched in on the clock to work. So that's how that goes. And again, we have to reflect that on the pay stubs with your payroll. If you are on the accrual method, at the end of the benefit year, any amount of time that's not been used has to roll over. Now, the way I normally write policies is that I cap them at least 80 hours maximum accrual. So to me, the rollover doesn't matter all that much. I just think of it as I max it out at 80 hours. That's the most the person can ever have. Whether it's at the beginning or the end or the middle of their benefit year, it doesn't matter. They can't have in the bank more than 80 hours. That's the minimum. If you want to have a 120-hour bank or a 150-hour bank, you can totally do that. But minimum of 80 hours in the bank is what you can set for the maximum accrual. And then we don't really worry so much about benefit years. It's just like, well, 80 hours. You're just, you're constantly earning 1 hour for every 30 hours of work or whatever your ratio is. And then they max out at 80 hours with the bank. You can set, on top of that, you can overlay an accrual cap of 48 hours in the benefit year. So you could limit somebody who's on the accrual method, you could limit them to earning only up to 48 hours per year. And that, a lot of companies do that, and that's totally fine. And you could let them earn unlimited. There's only so many hours in the year technically to work, I guess. But you could let them earn an unlimited amount, or you could cap it at 48 hours if you wanted to. This is a very dense slide. These are the reasons, and Gina had mentioned already bereavement and planning for funerals that came from the last legislative session in 2024.
And we wanted to keep this to one slide, so we'll send this information out to all of you just to make sure that you have it, because it's a lot.
Yeah. So these are the reasons that an employee can use ESST. Can you have, just getting into like bigger picture things, can you have a specific policy that only allows employees to take ESST for these reasons? Absolutely. You can limit it. Could you expand and let people use ESST for any reason? Absolutely. That's more of like a PTO policy, right? Where it's like, I don't really care why you're leaving, but you're going to use this bank of time. So you can bifurcate it. A lot of companies will bifurcate it, and they will have vacation in one pool and then ESST in another pool. Or you could combine it into one big paid leave, PTO, whatever you want to call it. Kevin leave. You can call it Kevin leave. You can call it Gina leave. It doesn't matter what you call it.
Can I add something in too, though, Kevin? I think one of the things that trips up employers if they do the one bucket of time off is to make sure that you're still following the rules for earned safe and sick time. So if someone calls in, they're an hourly employee, and in the past you've asked them to find a replacement for them, with earned safe and sick time, the employee is not responsible for finding a replacement. So I want to make sure that we don't get tripped up on some of the rules, because you're still responsible for the minimum standard of earned safe and sick time, even if you do say we want to blend that into overall PTO policy. Mm-hmm. So there's some nuances that we still want to make sure we're managing or mitigating.
Mm-hmm. Yeah. How many of you are using overall PTO policies and bundling in the ESST? Yeah, I think that's pretty common. I would say maybe a little bit more than half the policies I write are combined PTO policies. And like Gina said, in the last legislative session, they surprised us and put in that provision to say that that you have to treat all the PTO time as potentially ESST covered. You can't, you either have to separate it out, vacation and ESST, or if you do a bundled PTO, the entirety of the bundled PTO gets the ESST rights under the law. But you can absolutely split it out and say, so for example, if you have a PTO plan, you can say, well, if you want to go biking in California for the week, you need to give us 30 days notice or 6 months notice or whatever you want to do. You set the standard. There's no rule on that. So because there's no law that says you get to go biking in California and take your paid time off for that. So you can set the rule. But if somebody says, well, my child is sick and I need to stay home, you can't require advance notice of that. If it's a foreseeable event, you can require 7 days notice. But if it's an unforeseeable event, like the kid's sick and can't go to school, you can't require any notice, and you can't require a medical note either unless they're gone for more than 3 days, kind of like the FMLA. So it's only where we can require documentation after 3 days. These are the family members that are covered. It's kind of like everybody and your neighbor. It's
and
ridiculous.
Your neighbor.
And your neighbor,
Literally.
including literally you could put your neighbor on there. Like, oh, my neighbor is suffering from cancer. I'm going to mow my lawn and take off time to help them out. I don't know. It's dumb, honestly.
Emotional support human, I think, is
whatever.
What I heard on a Netflix show recently.
There's, like I had said before, there's model legislation that goes around. The Minnesota legislation looks just like the Arizona legislation, which looks just like the
Massachusetts.
legislation in Massachusetts, like California. This is model legislation, and they all now have, Colorado too, they all have this whole, like, some random person that you met on the street, you can take time off to hang out with them, as long as they're sick. So
That might be a stretch.
Yeah.
But yes.
Go ahead. Yeah. Oh, is there a formal? Yeah, I'll repeat it for the. Is there a formal definition for domestic partner? And so the answer is, yes. You have to meet. You have to be a legal domestic partner under the law, under the state law. What that is, I don't remember what that is. But and I think things all changed once gay marriage became legalized and part of the Constitution stuff. So, but yeah, technically, the domestic partner, it's not as big of a thing now with legalized marriage. So, but yes, technically there is a legal definition.
There's another
Yeah.
question.
Can you require your employees to take time off? Or like
It's-
mandatory leave?
Can you require employees to take time off? It's a really good question, and you're going to get different answers from different lawyers. But I'm going to tell you what my answer is.
And then
Absolutely.
I'll tell you the non-lawyer response.
So yeah, you can. If you've got some employee who's like, I'm going to tell you situations that come up for me periodically. Employee's pregnant. They want to save their time for bonding leave, right? To take their full 12 weeks, and they want to have as much pay as possible later in the year. I don't know why, but they then say, well, I also have COVID. I can't work this week. I don't want to use my ESST. They don't have it. You can force it on them. There is a provision that where you can't obviously force it on them if they don't meet the requirements, the eligibility requirements. But if they meet the eligibility requirements, you can require that they use their bank.
And I like to address it from a relationship standpoint. So I go into also work comp land to say if someone is working and working and working, they're not taking PTO, it's really a safety risk to them and their mental health. So I really try to approach it from what do they need from a break perspective. And then I do have another client that has collective time off. So they have 2 weeks a year where the entire company shuts down. It's August and around the holidays. So there's creative ways to address the concerns as well. But I usually, if someone's resisting to take time off, I usually go down the work comp road to say it's in the benefit of the organization and for your mental health to take a break. Does that help?
It does.
Okay.
Is that full and part-time employees?
So we're going to get into the part-time employees with the medical paid family leave because everyone on your payroll is going to be covered. And I really think that if anyone in here has a question like that, it's good to get specific guidance for your organization because I also want to account for your culture and what is it that you're really trying to guide because anytime, and I don't know if Kevin will agree with this or not, that it's really about what is the court of law going to approve and how are you treating your employees. So there's a lot of ways to do a lot of different things in the HR space, as long as we're not violating the law. So there's a lot of flexibility.
Yeah, as far as ESST goes, I mean, it's pretty neutral with regard to full-time and part-time employees. That's different. The cultural piece is different, but the other thing is like if they don't want, and this used to come up back in the day with FMLA, and it still does. Like, the person's like, oh, I don't want to use my FMLA. Well, you don't have a choice. Like, if you meet the eligibility criteria for FMLA, I'm going to put you on FMLA. Here's your designation notice. But the other thing is, well, if they take that week off for COVID or whatever it is, well, ESST is job protected leave, just like PMFL that we're going to talk about. It's job protected leave. So technically, you could accrue unexcused absenteeism for them if they're not using their ESST for this time off that's now unexcused. And it's like just because somebody's sick, they have the flu or whatever, that's not protected leave. I mean, if it's FMLA, it is. But unless they use the ESST or PMFL next year, it's not job protected. People always think like, oh, I have a medical note, like that somehow excuses me. There's no law that says show a doctor's note and you get excused from an absence.
So if you're using just like your PTO policy because it's more cumbersome, has more time,
Mm-hmm.
you have to treat all of that as these.
Correct.
So then,
Yeah.
if they are off because of COVID or they're sick with the flu or influenza was a big one this year and they're gone for 2 weeks, technically they're protected.
Yeah.
You don't think they're being off.
Yeah. So the question is, and this is the change that happened in the legislature in 2024. So the question is, if you have I'm just going to give like a number. If you have 5 weeks of PTO for somebody, but you're like, but we only give you, technically we only think of it like 48 hours of that is ESST. The rest of it is generalized PTO. But anyway, it's a whole big pool of 5 weeks of PTO. That entire 5 weeks could potentially be have all the rights for ESST. So I'm going to give two scenarios. So one scenario, the employee, they blow way past that 48 hours, and they use 4 weeks because they get the flu or something really bad, right? And they use all 4 weeks. Well, the 48 hour, it doesn't matter. That entire 4 weeks of time off, that's job protected. Because if you go biking to California, that's not job protected. Right? But the whole 4 weeks, they could take up to 5 weeks under the PTO bucket, job protected leave, if it's for ESST related reasons. And so you have to give them the notice, and the doctor's note applies to it. And so there are scenarios, especially with like an intermittent leave situation, there are scenarios where doing a huge PTO bucket can be disadvantageous to the company because you've now extended these rights for the entirety of the PTO, as opposed to if you bifurcated and they'd only have the rights at the first 48 hours, and then if they continue to have the flu, again, not a disability, and we'll just pretend it's not FMLA and you're not covered, and beyond 48 hours, they really don't have job protected leave. So that's the one downside. The other thing I would say, because there's been a lot of misinformation about this in the last couple of years, is that if you have an overall PTO bucket and the person goes on that bike trip and they take all 5 weeks to go biking in California and then they get the flu, well, they're out of luck. They've used their entire pool of 5 weeks. Just because you didn't use it for an ESST related reason doesn't mean that you have suddenly like extra time, paid time off under the ESST. There was a lot of misinformation about that a couple years ago, and so hopefully memos got out that that's how it works. Great questions. Any others?
I have one.
Okay.
So essentially, it's kind of like, as of now, if they're requesting a week or 2 weeks to go on vacation, I can require an advanced notice, and then they find their own replacement. But as soon as they figure out that if they don't request it off in advance, and then all of a sudden they're sick, and then like their child is sick, so it's kind of how they phrase it. Like if they're
Yes. So the question is like, if a person, and I'll give you an example. So if the question is if the person wants to go, we'll just keep going with this biking thing. Gina, by the way, is taking a biking trip in California. This is why I keep using this. This is like very exciting. So if for 2 weeks, the person wants to take their biking trip in California, and you're like, yeah, I need you to find a replacement. I need you to give me 6 months notice in advance, all that. And then the employee is like a little smart, and they're like, or my kid could be sick for those 2 weeks, and I tell you the day before, and I don't have to find a replacement because I don't like you, and I hate this job, and all these sorts of things. There's not a whole lot you can do. Now, in the 2 week scenario, you can ask for medical support because they've been gone for more than 3 days. However, they changed the rule last legislative session. And they said basically it doesn't have to be a medical note. A person could even sign off themselves. My son turned 18 when he was a senior, and suddenly he was like signing himself out of school like all the time. Like he didn't need, like his days of needing me to sign him out of class, they were over. That was like his independence. That's basically what the legislature did for employees, to allow them to basically, get out of work free. Like, oh yes, my daughter was been sick with COVID, and you can't require any more document. This is why this law. This is the area where this law is stupid, and should be fixed. Probably won't be, but this is the type of scenario where the law is dumb.
I'm going to stay on her 2 week for a second, because I think you skirted around something that possibly comes up. So the employee actually lets you know that they're going on a 2 week.
Yep, the employee lets you know that they're going on the 2 week
Okay.
trip to biking trip.
Changes their mind and says, well, I'll just use the sick and safe law instead and call it sick for the same 2 weeks.
Yep.
Because they don't like their manager or supervisor.
Yeah. Yeah.
But now you're telling me that they're still protected, but isn't that retaliation from the employee to the employer? Where's our protection?
Yeah. So the question is right. So thank you for the clarification. So the question is, if the employee tells you, "Hey, I've booked this trip to California," and you're like, "You got to find somebody," and they say, "I can't find. Nobody wants to work. That's like the best year of the summer. Nobody wants to work to replace me on my shift, so I can't." And so then you say, "Well, then you can't take it off." And then the day before, they call you and they say, "My daughter's sick. Seems pretty bad. Probably not going to be in for the next 2 weeks." Or you just call in every day, like, still sick, and that goes on for 2 weeks. And the employee's full of beans, and that this is false. And so you have two choices. One, you should ask for the medical note, and then they can just sign off something and be like, Sally was sick, and I guess, so the answer is, what rights do you have? No, I think you're kind of screwed. So, like,
Posting on Instagram every day that they're on their trip.
you can take that shot, you can take that chance, you can deny them. There is no such thing as employees retaliating against employers. Like, that's not a thing, unfortunately. It only goes one way: employers retaliating against employees or interfering with their ability to take the leave.
Could you part ways?
Could you part ways?
Or at will, right?
I mean, it would look like interference, right? Could you fire them? You'd have to give a reason. I guess what I would say is this is a high-risk termination. And so I would, I think you need to decide what your risk tolerance is in this scenario. And if your risk tolerance is, hey, I want to get clarification on this law, and if I have to go to the Supreme Court of Minnesota to do it, I will do it. And so that works for me as a lawyer. But if you are risk adverse, you just take it, you just chalk it up as, this is where this law sucks.
Can I add in too, from an HR perspective, is I would be managing that employee's performance. So sometimes they say you let the right shoe drop first and then you let the left shoe drop, or you manage to what shoe is the most important and figure out how to get a new shoe. So one of the challenges is that you've now learned that employee's integrity. And I think that you manage to the performance ongoing so that it's not a high-risk termination, but you now know where that person stands. And I think that's the most important thing when we're in business, is how do we treat all of us in the most ethical, integral way possible. And it's just taking advantage of the system. So, and there's going to be people that take advantage of the system, whether it's earned safe and sick time or the paid family leave. And that's where I think we just have to have more conversations with people to make sure that we're building really good relationships. So you're not going to, with any law or any rule, in my opinion, you're never going to avoid the bad apples. I just don't want to lean into making rules and regulations for the bad apples when we have like 90% really great people that work for us. So I would say that would be a call for either to me or Kevin to say, hey, we have this situation, how do we handle it? Because I'm a really high risk person, and I don't want to spend time on the back end in a lawsuit. So I'm going to try to guide you the best way possible to avoid additional litigation and not be in a high risk situation.
Yeah.
Usually I say give something 30 or 60 days. So just bake that into your process. If you are frustrated we need to have 30 or 60 days to manage through the situation, is what I typically guide.
Yeah, I totally agree. Like that employee, if an employee does that, you're going to be able to get them on some other bad attitude policy. They're not long for you, whether it's self-selected by voluntary termination or involuntary.
And I would say if they're showing their true colors there are probably other colors that you haven't uncovered yet. So if they're non-exempt, I would go look at their time cards. There's a lot of organizations and a lot of non-exempt employees who sometimes falsify their time cards or manipulate their time cards. So I would just be more aware of what that employee is doing. Okay.
Other ESST questions?
Just one quick one.
Yeah.
Somebody that took a vacation, did actually get sick on vacation, requested to switch to ESST. Do we have to switch to ESST?
I would, yeah. In that situation, they get sick on vacation. It's initially a PTO, class. Yeah, you have separate buckets. Then I would switch it to the ESST bucket if you have 2 buckets. I'd switch it from the vacation bucket to the ESST bucket. Yeah, I think that's the right thing to do. If the employee wants it to stay in the vacation bucket, you could do that, but I think switching it to the ESST bucket would be appropriate.
Kevin, we have one more.
Oh, yeah. Sorry.
So if you have everything in one bucket, it's really hard to have an attendance policy, almost impossible to have an attendance policy for employees to follow if everything is subject to the same rules as sick and safe.
It's hard. So the question is it's really hard to have accountability on attendance and an effective attendance policy with an overall PTO bucket. And I would say it's a little bit more challenging in especially if you're in a workplace where you do need people to get coverage for their absences. A lot of employers don't need employees to find somebody to cover for them, but obviously if you're in like hospitality or like nursing, there's a lot of, or home care, there's a lot of industries where you need the employee to like find somebody, to cover their shift. An overall PTO bucket would be hard in that it could be because of the manipulation ability. So, but it's easier to manage one bucket in many ways, right? I mean, it's, but I still think the best way to not give employees time off is to have 2 separate buckets. Because really, if they're not sick and they don't use the ESST, then you haven't combined. People will always find time off for a vacation, but they might not hit the criteria and they might not know well enough to manipulate it to use their ESST. So they might just leave that ESST, let it go without being used. And especially if you have a use it or lose it, they don't, then it just goes away at the end of the benefit year. Yeah.
Do you have many people have unlimited vacation?
Yes, unlimited vacation. Yeah, unlimited PTO. It's normally an unlimited PTO. Yeah, and then, that's the hot topic the last 5 years, right? For certain employers, it really is so hard to manage an unlimited PTO plan. It works well in primarily professional environments, especially where they're production based, where you can measure somebody's performance based on their productivity. Think of accountants, IT, where they're billing, lawyers even. We have unlimited PTO for our for lawyers because it's easy. Sales, yeah. Who cares how much time off a salesperson takes as long
They're bringing in money.
As long as they bring in the money. Yeah. But when you talk about heavily non-exempt or blue collar staff, unlimited PTO is so hard. Like it doesn't make a lot of sense.
You can have
Yeah.
multiple PTO policies within a
Of course, yes. Multiple PTO policies within a policy, absolutely. Within by department, by classification, No discrimination. No. Just don't do it within the same. And you wouldn't be like, oh, we're going to give the men more, and we're going to give the women that would be
Could, the
bad.
manager, the county manager have
Absolutely,
more,
managers could have more.
PR person that okay.
Absolutely, yeah.
Title, you can use the titles.
So again, you have
Yeah.
it all in one bucket, it's kind of how they phrase it. So if I have someone that wants a weekend off and it's their weekend to work, but they're saying they're going on vacation, I can ask them to find their own replacement, as long as they're not saying it's because for a ESST.
Correct. If you have an all-in-one bucket or even separate buckets, and the person says, just repeating it for the, and the person says that that they want to use it for a vacation, you can put whatever criteria around notice that you want. You could have the person like do a cartwheel and a handstand for 30 seconds in order to be eligible to take that. Like, you set the criteria. You cannot set the criteria for ESST use. But for every other, like if Gina wants to take her bike trip, be like, okay, Gina, first you need to like show me that you're gonna be able to bike 60 miles an hour. Be like, I can't do that. Well, then you can't take your PTO, so.
And what I think of with earned safe and sick time or the paid family leave is these are minimum standards set by the state. So the company can always add and modify and adjust as long as they're meeting the minimum standard. I think we have one other question in the back and then we can move on.
Great. Yeah. Sure. Yeah, so you have two different ways of addressing ESST. One for exempt employees where it's unlimited, and then one for non-exempt employees where you put them on an accrual basis. Front load at least 80 hours. 48 hours. Okay, so are you doing the use it or lose it on the 48, or are you letting them? Okay, so you're paying out any unused portion. Yeah. And you can have an unlimited ESST for exempt staff. That's entirely fine. It gets a little hard when if somebody were to come down with like a chronic condition. Yeah. And it's kind of like with these unlimited PTOs, normally we put some framework around it to say, well, it's unlimited PTO, but for longer term absences, it's not unlimited PTO. It's harder to say that, and you have short-term disability. Yeah, it's a little. I mean, with the short-term disability, you can come in, and long-term disability, but
I
it is a
want
little
to make sure
hard.
it was written into the policy. I did have a client that had unlimited sick time, basically earned safe and sick time, and then someone was diagnosed with cancer, and they didn't have any provisions in regards to how long someone could be out. So I just always get curious about why are we making sick time unlimited unless it's wrapped up into a bigger PTO policy with some of these provisions on it, because there are catastrophic injuries and illnesses that I don't think the business wants to support long term.
Yeah, it just needs to be really structured correctly, and yeah.
I think our business has the short-term and the long-term disability benefits that it would fall to if it was over, sort of a chronic problem like that. So I think they're set up for that as a global organization. But I was more worried about if we were paying out the unused portion for the non-exempt, but not offering a payout for the exempt if they didn't use any.
Yeah, I don't think you need to use it. Right, you're going to have to pay out an unlimited amount, an infinite amount of money. Right. Yeah, no. I mean, you don't have to pay it out. So in that situation, the unlimited is, we're going to call it more than 80. So you should be fine, on the front load. Yeah. Any other questions on ESST? Great questions. Okay, we're going to move to PMFL.
And then just to call your attention, I know that some of you have it on your tables, and we'll send this out electronically to those who are online, but we do have a document that talks about the distinctions between paid sick and FMLA, or PFML. And if you don't have an extra copy, we do have some at the front of the room that you can grab at the end of the session.
Anybody heard about this new thing? Okay. Everybody going to go to the chamber event next week. Highly recommended. It's good to hear it from Deed, what they're how they look at this. But I will be very curious to see what comes out of this legislative session, if anything, regarding PFML. So, Minnesota, unless things change, January 1, 2026, everybody in this room and everybody in the state of Minnesota is going to be required to be paying into payroll tax to the state to fund a new program that's kind of a mix between short-term disability insurance and unemployment insurance. It's going to be run through the Minnesota Department of Employment and Economic Development, DEED, and you'll be able to access your DEED account through your unemployment account. All of you have DEED accounts. You should. You have to. So. So everybody in this room has a DEED account, and you will be able to access the PFML usage by your employees through that account. Now there are two, and Gina will talk to this more than I will, but there are two structures for this. There's the public structure, which I think probably most employers, especially smaller employers in the state of Minnesota, will be on, and that'll be run through DEED. And then there's a private insurance plan that Gina's going to talk more about, and that's probably going to inure for larger employers. I don't know where the threshold is, if it's 30 employees or 50 employees or whatever it is. But there's also a private insurance plan. Benefits, payroll tax is going to be paid either to the private plan as a premium, or it's going to be paid to the state of Minnesota on your 941s through quarterly payments on your 941s. The payroll tax, I'm just going to call it a payroll tax. I know you can call it a premium, you can call it whatever you want, but it's a payroll tax. It's 0.88% in 2026. However, it almost certainly is going to change in 2027. It could go as high as 1.2% under the current law. So it could go lower. Some states what we've seen in other states is that in the first few years, they tend to go a little bit higher, and then they tend to aggregate out and go a little bit lower. We'll see. The Minnesota plan is a little bit different than other states, and I wouldn't be very surprised to see that the state of Minnesota is overspending on paid leave under this program than they are expecting. So I would expect the payroll tax to go up next year beyond 0.88%. That 0.88 is split in Minnesota 50-50. So you could charge up to 0.44% of the premium to your employees. The other 0.44%, the other 50%, is paid by you. So if you haven't priced out how expensive this is going to be, look at your W-2s for 2024. Cap out anybody who's a high wage earner above the Social Security max, because you don't have to pay this premium above the Social Security max of $176,100 in 2025. And so you can figure out how much it's going to cost you as a business. Take 0.44%, multiply it, and you can figure out the cost to your business next year estimated. And then that'll be the exact same cost to your employees divided out by your employees. Does that make sense? I feel like I got too mathy on that.
Private is less than 0.88. Can you still charge the employee 0.44?
Yeah, you can charge up to 0.44% on the premium to the employees. That's my understanding as well. I will say this, there are a lot of questions that we are still waiting on. We have proposed regulations that came out, proposed rules from the DEED that came out on this in January, but they have not been finalized. My guess is they won't be finalized until after the legislative session, probably because they might need to make some more proposed rules. But if the legislature does something, but we are under some current proposed rules. That might be an area that 0.4% question is one that I've had, and I don't have a perfect answer for it, but my understanding, something to ask the DEED person next week, but my understanding is that if you are paying less of a premium to the private plan, you can still charge the employees up to 0.44. So I could be wrong on that, so check with that unless you know.
I don't.
For sure. Yeah. To me, that's one of the open-ended questions that we have. Generally speaking, you get 12 weeks of time off under the PMFL. You get 12 weeks for medical leave reasons and 12 weeks for family, like bonding type of reasons. If you need to take both because of some sort of situation, It actually caps at 20 weeks. So an employee can't take more than 20 weeks combined between the two, but they could take separately up to 12 in each of the two buckets. Also, it covers all employees as long as the employees are making, it's like 5.3% of the average wage in the last quarter in Minnesota. So it's going to cover almost everybody that you're employed, unless you have seasonal workers or in very part-time workers that are barely earning much in the way of wages at all. As far as using PFML, again, I think of this as short-term disability. Think of it as like FMLA, short-term disability. It's going to start right away if somebody needs time off for a medical reason. And we'll talk about why ESST is relevant in a second on this. But we have medical reasons, very similar to your earned sick and safe time reasons, medical, safety, and then family, parental leave, and then active duty military. And again, we have these two buckets between the family stuff and the medical and the medical buckets, up to 12 weeks total. Okay. Procedurally, unless things change, this is the plan for how it's supposed to work. The employee is going to give 30 days notice. It's going to happen, I'm sure, 100% of the time. 30 days notice, absolutely. Here's why I need it. I'm going to have a baby, or I'm going to get COVID in 30 days, whatever. 30 days notice if it's a foreseeable event. They apply to DEED. They go in, they have their own account with DEED. And by the way, in case I forget, at the end of this year in 2025, you have to provide notice. In I think November or December, you have to provide notice to all the employees.
By December 1st.
By December 1st, yeah, 30 days before, yeah. So by December 1st, you have to provide notice, so employees actually are supposed to know about this.
Or date of hire.
Mm-hmm, yeah.
Moving forward.
Yeah, moving forward, date of hire. It'll be part of your documentation that you do with pre-hire notices. Yeah. So you've got the employee notifies DEED 30 days in advance that they're going to need to get benefits under this program. DEED looks at it. They check to see if the employee's got W-2 wages sufficient. I think, like I say, I think it's like 5.3% in the last quarter. And so to see if they're like an active worker in the state of Minnesota, DEED will then notify you. You have two choices. One, you could just ignore it, in which case DEED will make its own decision on the employee's eligibility, and they'll probably just rubber stamp it and pay out all those sweet benefits. And then, or you can respond and say that you disagree and that this is fraudulent, right? So you have the ability. It's not retaliatory as long as you're not intentionally claiming that it's fraudulent. It's not considered retaliation. You can do that. So you can, those are your two options. And then DEED will make the determination. Let's all hope for the state of Minnesota budget that DEED is actually discerning and makes really good informed decisions, and they just don't rubber stamp everybody. This is where a private plan might be, if you're like 50-50, like, I don't know. Even if it's more expensive, a private plan might be the better way to go, because a TPA hopefully would be, through a private plan, would hopefully be doing a better job than what we might see out of DEED. I don't mean to be cynical, but I remember I still have scars over unemployment with DEED during COVID, and how they just gave everybody benefits, and their children benefits, and their unborn children benefits, and it didn't matter. And I understand they've hired like 300 people to run this program at DEED, and it's a whole new thing, and it's run by a guy who was very successful in Massachusetts at running the Massachusetts program, the Massachusetts PFML. So I'm hopeful, but I'm also cynical. So
and we're super excited that we live in such a great state. I think the challenge is that this is not DEED's expertise. They're not a TPA, and we have 40,000 plus businesses that are going to be run through the state, and they don't really have everything set yet. So my challenge is, how do you put yourself first as a small to mid-sized business to make sure that you are heard and can manage the situation with your employees if they're going to be out? Because it's not only about ease of use. The state, it might be easy to work with the state, right? It might be less expensive. But I also wonder about administration and what the cost-benefit analysis of that is. So I think that really every employer gets to make a choice at this point. Yes, there's a fee to opt out of the state plan. And we have a quick reference guide on some of your tables as well that goes through some of the highlights of this slide. And at the bottom of this, which we'll also send out to you, there's an ability to ask for a quote for a private plan option. We're doing this out of the goodness of our hearts because we know that small to mid-sized businesses need support at this time. So it's really about making sure that you have all the support that you need to make the best decision possible for your organization.
Yeah. Anyway, we'll see how Deed does. But my concern is that they're just going to rubber stamp everything, and I hope I'm wrong. But anyway, they will make the determination, and then Deed will pay it out. They will pay out I'll go to the next slide. So this is what happens if Deed approves. If Deed approves, the payments begin within 7 days. There's no waiting period for bonding leave. There is a 7-day waiting period for medical leave. However, even after that 7-day period, they anyway, they go retroactive to the first day that the person was off. So even with the 7-day waiting period, they still get paid, but there is that waiting period for the medical portion. So Deed will approve it, and then Deed will start making the payments directly to the employee. You're really and then you're just notified of it, and this is job protected leave. Can't fire the employee unless they were a brand new hire within 90 days. Then you could, I guess, get rid of them. But otherwise, this is job protected leave, just like ESST.
So I think one of the big things that we're not addressing because we're talking about the actual program is I also want to address the fact that you have staff that's going to leverage this, and you have staff that might be in a position of one where there's not a backup to the work being done. So it's not only the cost of this program, it's the cost of your employees potentially not being there to move the work forward, and you might have to have supplemental staff or some other creative design to get the work done. So that's why we want to try to get ahead of this as much as possible, because it's also about the staffing concerns that it could present. I heard a statistic from the state demographer that up to 20% of employees could be gone at any one time on the paid leave. So if 20% of your workforce was gone, what would be the impact? And how are you preparing ahead of time for what that might look like? It's all about being proactive.
Yeah, especially if your workforce is paid on the lower end of the wage scale. And this is why. I don't know if you can all see. Wait, I'm going to skip ahead. I'll skip ahead and we'll get back to this point. You know what? I'll remember this point. We'll stay in order. So under the public plan, 0.44% next year. Again, this is going to change in 2027. And by the way, we will be notified, I think it's in June or July, we'll be notified what the 2027, so June or July of 2026, we will be notified of what the 2027 premium payroll tax is going to be, right? So we'll know in advance. But it's 0.88% total, half between you, half between the employee, up to the Social Security maximum of this year, $176,100. Next year, it's not going to be $176,100 unless there is 0% inflation. Anybody think there's going to be 0% inflation? It's likely to be higher. So, but if we take the 0.44% up to the Social Security max, say you've got a high wage earner that's earning exactly $176,000, or if you have a high wage earner earning $500,000, they're going to pay the same maximum, which is $14.90 a week. Okay, so that's the maximum under current numbers of what the out-of-pocket is going to be for a high wage earner. If somebody is making, obviously like less than that, they're going to be paying less, right? So it's just 0.44% of their W-2 wages. But this is how you can see what it's going to likely cost you next year from a premium standpoint from your business. Yeah. Questions on that? Okay. Otherwise, I'm going to get into numbers. I know this is a lot of math. Okay. Here's why your employees at the lower wage are not going to be showing up to work once they figure this out. It might take them a few years to figure this out.
Or not. I have.
Or not.
I'm
I'm hopeful.
You can hope. I work with people day in and day out. Different, right? Like,
Yeah.
I have a client where the employee is already doing a preemptive strike to say, as of January, I'm going to be taking time off, and here's why. So there are employees that already know this is coming, and they're informing the employer that they're going to take time off. And this person is, again, a person of one, doing the job of one, no backup. So the employer is starting to ask questions of, what can we do and how do we mitigate this risk? Because, again, on the lower end of the pay spectrum. So I like to hope. Someone told me as an HR professional that hope is not a strategy.
Yeah. Yes.
So I'm like,
Right.
got it. We need to come up with better strategies then. So.
Hope not a strategy. So, and this is why. So if you take a look, the average weekly wage in Minnesota is just under $1,400 a week. Let's just say it's $1,400 a week. Next year, it's probably going to be right around $1,400 a week. If the employee is making half or less than that, so $700 or less than that per week, they're going to have 90% wage replacement. Now, my daughter and all her friends, they all in high school, and they all in lovely St. Paul, and they all are they were on ESST. And they all got to the end of the summer, and they're like, oh, we still have ESST available. So they all went to the mall, but they were sick, right? Or I don't know what they said. But in any event, they used it all up. Employees are going to figure this out. Why wouldn't you? If you're a lower wage earner and you're making less than $700 a week, you're basically going to get you're going to get 90% wage replacement for not working. Okay. And that's where it's like you have to talk to the deed about it, and they'll be like, okay, yeah, you do seem sick. You should take 12 weeks off. This is where lower wage earners, this is where our unemployment's going to hit. Like, we're going to have serious staffing issues if the unemployment rate stays anything like this. So this is progressively tiered, right? So for the first, up to the first seven, again, we'll just use this $1,400 as the average weekly wage. Up to $700, they're going to get 90% of their wages. From $701 to $1,400, you're going to get 66% of that tier. And then beyond 100%, so anything over $1,400, you're going to get 55%. So if you take your situation where you've got somebody, let's just say the person's making like $5,000 a week, right? They're going to cap out at $1,400. Nobody's going to get more than $1,400, the average weekly wage in the state of Minnesota. So if you've got a high wage earner, they're not going to take the time off, right? They're going to get $1,400. They're used to making $5,000. I mean, it's better than nothing, but that's where they can then use ESST or PTO to top it off, to supplement, right? So you can make up that difference between the $5,000 and the $1,400, or you could have a short-term disability insurance policy. This is why short-term disability policies, they're still relevant, but they just come in and they might top it off. The difference between like the $1,400 and what the person normally earns. Does that make sense? Is that new to anybody? 5 minutes? Okay, great. Do you have anything to add on that? Oh yeah, go ahead. Sorry.
I know with short-term disability, if you pay the taxes on the premium, the monies that are paid to you are not taxed. What about for this program?
I don't know for certain, but I would be shocked if this is not income.
Okay.
I believe it's taxed.
Yeah.
Mm-hmm.
Yeah. That's a really good question to ask the person next week, but that's probably, my guess is it's taxed.
Okay.
Yeah, thank you for the question.
And
Yeah.
did you say that there is no waiting period like the FMLA currently, like
No waiting period. Yeah. No, it's not like FMLA where you have to work for them for a year and have 1,250 hours and yeah, no, they could literally start working for you, have a baby. I'm going to give you a really bad scenario that hopefully will not happen to anybody. Let's just say somebody you don't even know just had a baby today. It's April 16th. They just have a baby today. And then you hire them in like November or December. And then they come to you next January or February and they're like, hey, by the way, I'm going to take some bonding leave for 12 weeks for the baby I had last April while I wasn't even working for you. You can't stop that.
I did hear that.
Yeah.
I have heard that if someone has a child this year,
It-
this is going to be able to roll over into 2020.
There are the ability to manipulate they have to take the bonding leave within 12 months of the birth of the child or the adoption of the child. And so we are this is going to be a unique loophole for parents that have children in 2000, beyond after April of 2025 to then still take bonding leave in 2026 unless the legislature does something about it.
So mom takes her 12 weeks right now. Dad can actually take his leave in January of next year is what you're telling me.
Mom and dad aren't even working for you.
Right, that's what I'm saying.
Yeah, they're with another employer
I know that I could hire a new dad.
and not even know you're hiring a new dad.
12 weeks off.
And the dad's like, wait a second, I could get most of my pay to hang out with my kid or go hunting or fishing or whatever, and I'm a newer employee.
Here's the other challenge. I think as employers we've discounted the dads at some level in regards to taking bonding leave. So my now ex-husband, he only took a week for both of our children. So I got to stay home for 7 months. So one of those challenging things is we've probably discounted the amount of bonding time that men have taken with their children, and now we're giving them access to do that. So you're going to care about your women who are pregnant, and you're also going to care about the dads who are bringing children into the world as well, where it might not have impacted your business quite as much in the past. And I think that we should just continue to take questions on this because I think we're limited on time.
We only have like a couple minutes. Yeah.
No, you're good.
I have a dad that his wife will be having a baby. I hate to say his wife will be having a baby in June. They'll be able to be qualified for this. The 12 weeks. He figures he's not qualified for it.
You can take bonding leave within 12 months of the birth or the adoption or foster care of the child. And so that'll... And the FMLA doesn't even matter.
This
right?
is on top of FMLA, so all of
Yeah.
these are going to coordinate.
Yeah, hopefully they make some tweaks that this sort of thing can't be manipulated in 2026, but it is potential. Yeah. Correct. So if they have a baby this year and they take parental leave and or FMLA, and they're not eligible for another 12 months, right, to take FMLA, say they use all 12 weeks or parental leave, but assuming you have like a rolling calendar year type of policy, but will they be eligible under PFML? Under the current rules, yes. They will be. So they can basically take 24 weeks off within a 1 year period with you, and a bunch of it will be paid next year.
What if I had a baby last year?
Congratulations.
Well, and what I do want to call your attention to is in the quick reference guide for those of you who are curious about what a private plan option would look like. We do have a couple of different example scenarios for employers that have at least 15 employees based on the payroll that they have. And then there's also a JOT form. So if you do want to understand and look at what private options look like, Flagship would be more than happy to support you with that. Kevin and I are also more than happy to support you with any questions as you go through this journey. If we want to forward to the end slide where we have our contact information, we have our email and our phone number, so you can definitely reach out to us. And then I know there's a lot here, y'all.
We knew it would not be.
And
I'm doing a
so-
webinar tomorrow on drug testing. You're welcome to attend. It's free.
Yay, drug testing. So if you want to connect in with us, I have my LinkedIn QR code. You're more than welcome to link in with me or send us an email or phone call. And then I believe that the Chamber will send out all of the additional information as well. So Tim, thank you so much for having us.
Thank you, Kevin. Thank you, Gina. This was great information. I also want to thank the Dakota Scott Workforce Development Board and the Scott County CDA. I actually have action items for you right now if you want to get into some legislative stuff. Speaking of changes in the legislature, so sick and safe time modifications, there are currently 7 within the sections modifications. That is Senate File 2300 and House File 2025. Paid leave modifications, there are also now many different changes within that. That's Senate File 3141, House File 2962, and I'm going to send that information to Joe, which it'll call out in each section where those changes in the modifications are in those bills. Like I said, everything right now is in the negotiation phase for possible inclusion in the omnibus, so we will see what comes out from that, but we will keep everyone posted. Again, thank you for joining us today, and again, thank you to our sponsors. Yeah, quick question.
One more question. That lead meeting next week, how do you sign up for that?
Mark, will you send that? Do you want to send?
It does look like it's full. I was just checking while we were talking about it. So it's an Egan through the Dakota County Regional Chamber. But it is full and it does not look like they have a webinar available to it. But I think, Mark, am I incorrect in saying that there will be more of these?
I believe so, but there's also videotape of previous events, so you can go to that.
And one thing, yeah. And one thing too is I'll say is, I think it'd be valuable to have something after session, just because we are both earned sick and safe and both paid family modifications are bipartisan support in the Senate. So I do see changes coming in both of those. And there'll be there's some small employer exemptions. There's just different things. So I think if you guys are good with this, we could look at a possibility of doing a webinar or something like that after the legislative session, and then we'll know more about the rulemaking and everything like that. So, perfect.
Can I get a show of hands? Was anyone here for the cannabis side of things, or the misclassification of employees, or would they be interested in that as a future session?
Yes, that was,
Yeah.
we really can't hold them.
Okay.
Perfect. More topics. All right. Thank you, everyone. Have a great day.